Welcome to Visa Verge News, your go-to source for the latest updates on immigration and travel policies. Today, we're diving into a topic that touches nearly every international traveler: border searches of electronic devices like smartphones, laptops, and tablets. What are your rights, and where does the law stand? Joining me is Oliver to break it all down. Oliver, great to have you here.
Thanks, Victoria. This topic is incredibly relevant, especially as digital devices have become such an integral part of our lives. Crossing international borders with your phone or laptop is no longer just a matter of carrying hardware. It's about safeguarding highly personal data. Let's start with the basics. Under U.S. law, can customs officials search your electronic devices without a warrant?
Good question, and the answer is yes. Thanks to a legal principle called the border search exception, U.S. Customs and Border Protection (CBP) officers can search travelers' belongings at the border without needing a warrant or probable cause. This rule has traditionally applied to physical items like bags and contraband, but as technology evolved, it's been extended to electronic devices. What's interesting here is how this application has sparked debates about privacy and constitutional protections under the Fourth Amendment.
Exactly. The Fourth Amendment is central here. Normally, it protects individuals from warrantless searches, but the border search exception creates an entirely different legal environment. Critics argue that this overreach affects digital devices in a way that lawmakers never initially intended. Think about it. Your device could contain sensitive financial records, business documents, or thousands of personal messages. That's why there's such a push to clarify or even limit how CBP applies this authority.
Right. And this concern isn't just hypothetical. Recent court rulings have highlighted how differently this issue is being treated in various jurisdictions. For instance, take the case United States versus Sultanov from New York's Eastern District. Here, the court ruled that warrantless searches of electronic devices at the border went beyond the traditional authority of the border search exception. Essentially, they called these searches non-routine and said they should require a warrant supported by probable cause. It's a significant step toward enhanced digital privacy protections, but it only applies within that jurisdiction.
And then there's the flip side. In United States v. Mendez, the Seventh Circuit Court of Appeals upheld warrantless device searches, arguing that they are reasonable as part of broader border security efforts. That decision aligns with a more traditional view of the border search exception. It's a great example of why travelers face such inconsistent standards. What's considered legal in one part of the country might not hold elsewhere.
It really does create a legal patchwork. Many circuit courts like the First, Fourth, and Ninth say advanced searches, those involving extracting or analyzing data, need reasonable suspicion at the very least. Meanwhile, the 11th Circuit hasn't required that level of scrutiny. This inconsistency leaves travelers unsure of what to expect, depending on where they travel. But there's also legislative action happening, right?
Yes, lawmakers like Senators Ron Wyden and Rand Paul are backing proposed legislation that would require CBP officials to obtain a warrant before accessing electronic devices. This effort is partly inspired by the Supreme Court's 2014 decision in Riley v. California, which restricted warrantless searches of smartphones in police arrests. Translating that principle to border scenarios, the bill aims to unify patchy legal standards and strengthen digital privacy. If passed, it could represent a dramatic shift in how searches are conducted at U.S. borders.
And until any laws change, CBP has updated its internal policies to address some criticisms of overreach. Officers, for instance, aren't allowed to access cloud data. They must place devices in airplane mode or disconnect them from networks. They also have protocols for respecting attorney-client privilege and handling encryption. While these changes offer some transparency, they still leave the issue open to debate. For example, travelers may be asked to unlock their devices or provide passcodes, and refusing could lead to detention or having the device held.
Exactly. And this brings us to what travelers can do now to protect themselves. First, know the difference between basic and advanced searches. Basic inspections don't require suspicion, but advanced ones typically need some justification. Second, consider minimizing sensitive data on devices you bring across borders. Options include backing up your data, and leaving it at home or encrypting sensitive files. Finally, staying informed is key, and visaverge.com is a great place for updates.
Absolutely. This is one of those areas of law where privacy and security seem to clash head-on. CBP says device searches affect less than 0.01% of travelers and are critical for immigration enforcement. Critics counter that unchecked authority creates dangerous precedents that could invade individual liberties over time. The debate is far from over.
That's right. Whether through court rulings, legislative changes, or updated policies, the future of electronic device searches at borders remains uncertain. Staying prepared and informed is the best way forward for travelers.
Thanks for walking us through this important issue, Oliver. And to our listeners, thank you for tuning in. For more immigration updates, visit us at visaverge.com. See you next time.